The HR Stories podcast is brought to you by the team at HR Stories. The team at HR Stories helps businesses, nonprofits, and HR practitioners better manage the employee experience, providing the tools, training, and resources needed to get HR right. For more information, check out our website at theteam@hrstories.com. Each week on the HR Stories podcast, HR and leadership experts John Thalheimer and Chuck Smikian dive into the stories that matter most to you, our listeners. We have found that there is a lesson in every story. And now our host, John Thalheimer and Chuck Smikian. All right, Chuck, so what stories do you have for us today? What's happening right now that we need to be paying attention to?
John, a couple of weeks ago, the Wage and Hour Division released some interpretation letters. And if folks don't know what we're talking about, every couple of months or so, and they're starting to get better at this. There was a time there where they weren't, but they actually take questions, just like we take questions from our listeners. They get letters, and they get letters on interesting Department of Labor wage and hour questions, things that, people are like, it's almost like, walking a very fine line. People don't know, is it this? Is it this? Is it this? So they released two, which we would call interpretation letters. And one was in regards to FMLA and state paid parental leave programs. And I want to summarize that. Now, that may not sound exciting, but there's a lot of states out there, John, that have state FMLA and federal, Medical Leave Act. And then the other letter dealt with supervisors taking tips. And it's a hospitality, hotel, restaurant scenario that any of our listeners that have food and beverage operations, or anyone that's an operation where there's a tip or a tip pool, you're going to want to listen to. So which one do you want to hear first?
Well, let's go with the hospitality one, because I vaguely remember seeing something about this. And maybe it was another story where a manager was taking, there was another story. I'm not going to get into it, but there was another story where the managers and owners were taking tips.
Yeah. I mean, we've done stories like this in our HR Stories podcast. We have done HR in the news, but this is, so it's a common problem, and it's a scenario many hospitality employers face. You're short-staffed, team leader or supervisor or manager steps in to help the front line. They're cleaning tables, serving guests, doing non-supervisory tasks. But here's the big question. Can they legally share in the tips? And here's the answer. There's an answer now. The Wage and Hour Division released their opinion letter to clarify this issue. And the answer is, and it's our favorite HR answer, John, it depends. And in this case, it depends on how the employee is classified. In fact, I loved this opinion letter so much, and the contents. I actually wrote an article on my LinkedIn blog recently, HR news, HR in a nutshell. I went a little more in depth, but overall, hourly non-exempt supervisors can take tips. Once again, hourly non-exempt supervisors, if their primary job duties are non-managerial. In other words, even if they're the most senior person on duty on the shift, if they are hourly non-exempt, they can take tips. However, exempt managers and exempt supervisors, doesn't matter the title, okay? But if they're exempt, they cannot take tips. Even if they're bussing tables, delivering food, their primary duty, as defined by the Fair Labor Standards Act, is managing the team. And that classification applies across their entire work week, not shift by shift. So,
that makes sense.
Yeah, and the original request for clarification actually came from a quick service restaurant where the team leaders were pitching in on the line. And so Wage and Hour Division made it clear it's not about the title. And we've said this before, right? So, you and
Yeah.
I have talked about this. It's not about the title, it's about the duties.
Yeah. Yeah. And so what you're saying, let me just make sure that I sum this up. Leads, right? Typical leads that are non-exempt leads. They just happen to be the most senior person there. They can get tips if they're doing that role, if they're doing that part of the job. Whereas a supervisor, manager who is an exempt running the team should not be getting tips.
Yes,
Basically.
you're right. Yeah, and one more key point the letter had. It was like 3 or 4 pages long, a lot to get through on this. But they said tip pools. Some companies, some restaurants come up with maybe tip pools of only managers and supervisors. Like, oh, it's their tip pool and their tip pool. But that's not allowed either because it would involve taking portions of employees' tips, which the law prohibits. So there's a takeaway here, whether it's quick service spot or a fine dining restaurant, reviewing your classifications and policies is essential to avoid those violations. And I would be remiss, John, if I didn't say, if you need help, you navigating these rules, you want to check out our new book, which has been out there for a while, but it is now on Amazon.com, The Ultimate Guide to HR. Yeah, The Ultimate Guide to HR Checklist Edition. We definitely cover employee classifications.
Yeah, and it's funny because when I worked I worked adjacent to a restaurant, meaning I was doing theater and production in a dinner theater with all the staff and stuff. So I got to know the staff really well, and I learned about them. And there was numerous wait staff that I'm never going to become a manager because I won't get tips, and I'm not going to make the same amount of money as I do when I'm making tips. And it is, right? And so you have to make that choice. You have to make that career choice to be like, all right, where am I going? And so it's just an interesting thing. Understanding that really should help owners, restaurant owners, HR that are involved in the hospitality industry be very clear with your team. This is who gets tips. This is who doesn't. This is how the tips are split. This is how, this is what you need to do as a waiter. We expect you to give tips to the back house staff, right? And so making that clear and making sure that everyone knows. Yeah. And so that's kind of interesting to kind of see that play out.
Now, you said you had a couple of interesting news stories that were going to pique my interest.
Yeah. So I got one, right? And so I think you know this about me, that I am a die-hard Green Bay Packers fan.
Die-hard.
I own a little stock in Green Bay, as much as it was quote unquote. But there was a story the other day that happened in my home city of Philadelphia. Right. So the Green Bay Packers were playing the Eagles. Sorry, Packers, you lost. But there was this video that went viral of a gentleman pretty much berating a female Packers fan, using some choice language, which I will not use on air, but using some choice language. So this goes viral, right? This goes viral, boom. And I really appreciated the woman's attitude through this whole thing, right? She was pretty calm and calling me ugly. Okay, whatever. And rolled her eyes and just ignored the person there doing this. But this was all caught on tape. So what happened was this thing goes viral and people are like, he needs to be fired. Find out where he works. Get him fired. And so here's my question for you, Chuck. How would you handle that if one of your employees gets in a viral video for probably not the best reason? How would you handle that as a director of HR? What would be the process that you would go through to do that?
Yeah, I guess it would depend what their role was. If they were the HR manager, HR director, they wouldn't be able to represent themselves well in that role. If they're maybe a cook or a dishwasher, I don't know. I don't see that in a level of bringing that in, but It depends. It really does. If they were the youth pastor at my church, right?
Yeah.
And they were employed and that was them. Yeah. It's probably not going to be a good fit to keep them around. They may take away from doing their job. So what happened? Did anything happen to this person?
Yeah. So they found out who it was and the company it worked for, right? All these things happen. And the company was like, we're going to investigate. We're going to see what's going on, right? Which is the right communication out. Like, hey, we just saw this. We're going to figure this out. And, it was funny because you started listening to the experts. What would you do? And how would you handle that? They had two options, right? Well, they had two options. One was to fire the person immediately. Say, you're gone. You're representing the company. That's not a good look for a company. We don't want you here. And then the other one is just wait for it to blow over. It's not going to matter. It's not a big deal. Let it blow over, right? Something else is going to come up soon enough to do that. They ended up firing the individual. That individual happened to be the diversity, equity, and inclusion officer for the company.
Whoa. Okay. There you go. You couldn't have dragged me into that one any better. That is exactly, there you go. Boom.
Yeah, I don't know if he was the officer, but he had a role, and this company was very big on diversity, equity, and inclusion, and that kind of stuff. And here he is berating a woman, right? And it's just, I think people have to understand, and we talk about this all the time, is when you go out on LinkedIn, when you go out on social media and you connect yourself to the organization, if you're out in public, you're representing the organization. And if that organization doesn't think you're representing them well, they do have a right to let you go.
Yeah, especially if you're spouting off things that could be that would get, discriminatory type things. And, we've seen that. All right. That's an interesting, harassing. Yeah. That's a really interesting story. I like that. Probably more interesting than my FMLA opinion letter story, but hey, I'm going to make it exciting.
All right.
Hold on to your hats, folks. It's going to get interesting in here. We're taking off. So, okay, paid family leave is actually a hot topic. And especially as more states pass their own paid leave programs. But there have been a lot of questions on how does that states interact with federal FMLA rules. So once again, the Wage and Hour Division recently issued an opinion letter, and it is kind of a long explanation here. So I want to just get the top three things here. So designating leave as FMLA. So when an employee takes leave under a state or a local paid family medical leave plan. Sometimes, California, some places there, New York have local plans also. But when an employee takes leave under a state or local plan for an FMLA qualifying reason, like, caring for a parent after surgery or something, the employer must designate it as FMLA leave and notify the employee it will count towards our 12-week FMLA entitlement. In other words, the employer has to still run two tracks, shall we say. They're going to run the FMLA track, which is protecting the employee from on a federal job protected leave, and they're going to run the state and local. But they do have to let them know they're entitled to federal FMLA. A lot of companies forget that.
And so they're just giving them the state and going, hey, don't worry about the federal one. Okay.
Yeah. So they do have to do two tracks. They have to prove that they do.
I have always advised people when you're in that situation to run them concurrently anyway, right? Because you don't want somebody to use up their state thing and then come back and then use their FMLA, right? You want to use them concurrently. And I'm assuming that's still the guidance that you can do that.
Yes, absolutely. That guidance falls into this first thing. The second thing is called the substitution of paid leave rule. So there's something called the FMLA FMLA substitution rule, which allows employees to use their accrued paid leave like PTO or vacation during FMLA. And it does not apply when the employee is already receiving income from the state or local paid program. Many of our listeners may not realize that the federal FMLA it's an unpaid program, but many state and local programs do offer some sort of pay. So in simple terms, if an employee is getting paid through the state program, they cannot unilaterally use their accrued paid leave to top off their pay. They can't use PTO to top off their pay unless state law and the employer allow it through a mutual agreement. So no double dipping there in a way. So and then the other thing that the third thing is if the state program only pays a portion of an employee's salary, like 2/3 income, the employer and the employee can agree to use the accrued leave to make up the difference. So you can make up the difference, but you can't go above and beyond what you would normally be paid. So it's not a money-making endeavor, is basically.
Well, which makes sense.
It make you whole, okay? But you can't. So I thought that was pretty interesting. They put some examples in there, which, we only have a certain amount of time here, John. We got to get to our main story, but I did want to bring up this very important opinion letter.
I'm glad that you did. I always forget about those letters, and they're a great resource to have, to be like, oh, so this is what I want to do. And again, you can ask them questions, and they may not choose you, but they choose a lot of people, and they'll come back and go, okay, here's what we're thinking about that, right? And they'll put it out public so we can see it. And so it's good information. So it's a good reminder to look at those things. And they were on the Department of Labor website, right? The letters, the opinion letters. Is that where?
Yeah, they were. And, I will tell you that, that the bottom line for this one is knowing these nuances about when employees a state paid leave program and how these rules work. That's important. But overall, FMLA, there's a checklist for that, John, in our new book, The Ultimate Guide to HR Checklist Edition. Just had to throw it out there one more time because it does fit. It does fit. You want to go to ultimateguidetohr.com or go check us out on Amazon. Search for Ultimate Guide to HR. John, do you have another story for us? Or are we ready to take a break?
No, let me get into this just a little bit because this came out a couple weeks ago, came out the day we're recording this, but the Supreme Court, the United States Supreme Court, sides with businesses in overtime minimum wage case. Whoa, what does that mean? Okay, so they were talking about, went in front of the Supreme Court case, they were talking about how do we prove somebody is exempt from overtime and minimum wage standards? And so what happened was this gone through the lower federal courts before it got up to the Supreme Court. So some of the lower courts judges have said businesses have to have clear and convincing evidence that someone was exempt from Fair Labor Standards Act's overtime and wage rules, right? So making somebody exempt. Other judges said, no, businesses need to have a preponderance of evidence in favor, which is a lower level of proof. Do that. Right. And so this went up to the judges, and judges concluded that the default preponderance standard governs when an employer seeks to prove that an employee is exempt under the Fair Labor Standards Act. The case that there was a dispute with salespeople, whether they were independent contractors whether they were supposed to be exempt or non-exempt. And so it's interesting because they said they've gone up to the Supreme Court, and the Supreme Court says, well, it's a preponderance of evidence that you need, right? That's the standard. but they didn't settle the case. They're like, you got to take the case. That's going to go back to the lower courts. You're going to have to deal with the case itself. And so it'll be interesting where that case entered. To me, reading this, I don't think it's a big change. We have always talked about a preponderance of evidence, meaning that there's enough evidence to prove that they're exempt, and not like we need clear all like everything buttoned down to the last thing, which kind of leads us to our story today, Chuck. And kind of that in a way leads us to that story of having gray areas and decisions that we're making in the HR world and the employment world and all that kind of stuff. So yeah, let's take a quick break and we'll be back.
John, I just love answering our listener questions. And it just reminds me that no matter what you do, we always talk about systems and having the right systems in place. So Bamboo HR is an HR system. And it's one that if you are out there, folks, and you're wondering, hey, we need a new system, or maybe we're not big enough for a system, you really want to check out Bamboo HR. One of the things about Bamboo HR, as I have come to experience it is super easy. It's easy to use, it's easy to learn, easy to implement, and it is easy to love. There are clean interfaces, it's colorful, it's extremely user-friendly. If you get a chance, why don't you go ahead and check out a free demo of Bamboo HR. The team at HR Stories is endorsing Bamboo HR, and we would invite you to go to bamboohr.com/free demo. That's bamboohr/free demo, and get back to what you actually love to do in HR. Welcome back to the HR Stories podcast, where there's a lesson in every story. Today's episode dives into a fascinating case about promotion, fairness, and the role of intangibles versus technical expertise in hiring decisions. This is a recent court case from 2025, and we're talking about the Cunningham versus Department of Defense case. It is a story filled with ambition, disappointment, and some key takeaways. Actually, several key takeaways for HR professionals.
I like that. You put your movie voice on there. You're like, story filled with ambition, disappointment. It sounds like an HR conundrum. Where do we start? Let's set the stage for me.
All right, let's go back to 1988. Dun, 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 dun.
Where were you in 1988?
So it's 1988. Setting the stage here, Gwendolyn Cunningham starts her career at the DFAS as a part-time secretary. She has a high school diploma, but a drive that could not be matched. She wasn't just clocking in, John. She was building a future.
I love that, but I wanted to know what DFAS was. And what I found is it's a Department of Defense agency. It's called the Defense Finance and Accounting Services. So that's a big job, right? And so it's kind of cool that she went from a part-time secretary to a supervisor. That's really kind of cool. She climbed that. She did that. I love that she had that drive.
Yeah, exactly. And by 2012 now, so we're starting in 1988, right? So now we're in 2012. She's promoted to a level called GS12, which is getting up there. It's a supervisor leading the benefits team. But here's the rub. The ladder stopped there. The DFAS had no internal pathways from GS12 up through GS14, up to GS14, which was that next big step, that next big leadership role.
So there was no way, there was no plan for somebody to go, once you get to GS12, it wasn't like, oh, your next role is GS14. That was a big gap, and they didn't have a path to get there. So she was kind of stuck. Like, she's like, hey, I'm stuck in my career. I don't know where to go, and I'm stuck, and there's no way for me to go unless I go cross promotion, maybe work somewhere else. she's kind of stuck.
Yeah, that's what it felt like. But then her manager, Howard Locke, who really valued his team, all right, he gets promoted. So her manager gets promoted, and he recognized the gap. He said, there's a gap here. We need to create a bridge. And so they created a brand new GS-13 supervisor position to oversee both the benefits and workers' compensation teams. And it was meant to give someone like Gwendolyn a chance to grow.
So there's an opportunity now. Things are looking up.
Yeah, and that is true. But here's the catch. The hiring process for the new GS-13 role didn't start until the incoming benefits division chief, guy named Andrew Hartz, was on board.
So everything got delayed, and it was more of like, okay, we have to wait. We've all been there, right? We've all been in that role. Like, well, you have to wait until the new supervisor's in place before we can make a decision on this, right? I get that. I feel her pain.
Yeah, so now it's going on, and so Hartz arrives, and he takes charge. And then he and Shantae Jones, who was the supervisor of talent management, built a rigorous interview process. They really wanted to get this right. They didn't want to just look at technical knowledge. They focused on 4 key areas: subject matter expertise, leadership skills, process innovation, and customer service. And they designed 6 standardized interview questions for this, and most of them were behavioral. So it was a well thought out process.
Yeah, I love that. I mean, I think that's what we want our clients. That's what we want people to do, is to have a clear, strong interview process so they can make sure they're hiring the right people. And I love me some behavioral questions. I love them, right? And so just for our listeners, if you don't know, and I'm hoping you do know, but if you don't know, behavioral questions are those questions that start with, tell me a time, describe to me, give me an example, right? And so my favorite behavioral question is this. This one is actually in our book, The Ultimate Guide to HR Checklist. It is, tell me a time when your supervisor gave you some constructive feedback and it was objectively wrong. How did you handle that?
Okay. Well, and here's unfortunately where things took a turn for Gwendolyn, because how you answer those questions can really, sway an interview, because you're looking at someone's past performance is indicative of the future performance and trying to understand how they would handle these situations. So Gwendolyn had deep subject matter expertise. Her Hartz, the big boss, even called her the best SME that he'd ever known for this role. But her answers didn't resonate as strategic. So she's subject matter expert, but the answers didn't resonate as strategic. For example, when asked how she would train a growing team, she said she'd handle the training herself.
That's kind of ambitious, but probably overwhelming if you're managing a big team, right? And so now when you're moving up to that level, the GS-13 level, where you're going to oversee 2 major departments, you're not going to be able to train and do your job at the same time.
Yeah. So Hartz noticed that her approach then didn't scale well. That's a quote. Her approach didn't scale well, unquote. And on the other hand, Emmanuel Griffin, who was another GS-12 applicant, shined. His resume highlighted 23 years in the Air Force, private sector experience, training over 1,000 employees, leadership and workers' compensation. And during the interview, his answers reflected what they considered long-term thinking, strategic solutions, not just quick fixes.
So does DFAS choose Griffin? But Gwendolyn felt the decision was unfair, right?
Yes, that's what happened. So Gwendolyn, Ms. Cunningham says, you know what? The hiring manager prefers working with a male colleague, and that's what she believed.
Really?
Yeah. So Gwendolyn later shared that Hartz told her he wanted, and this is a quote, something different for the benefits division, a new direction. And she believed and interpreted that as different being meant for hiring a man. So she filed a complaint with the EEOC, alleged sex and race discrimination, then later filed a lawsuit under the Title VII Civil Rights Act.
So did the EEOC, the Equal Employment Opportunity Commission, agree with her claims?
No. So they did not. They found that there was not enough evidence of discrimination. So just real briefly for our listeners, when you have a discrimination situation, you do file it with the EEOC, and the EEOC will do one of several things, but overall, they'll either take it and run with it and go to the next step, or they may say, you know what, there's nothing here that we see as overt discrimination. So, you know what, maybe there is, but we're not going to deal with it. So you have a right to sue. They'll issue that letter and they'll say, now you can go find your own attorney and move forward, which she did. She was undeterred by that ruling from the EEOC, and she filed a federal lawsuit. And the court examined her claims, but ultimately ruled against her. They emphasized that her heartfelt belief wasn't enough without concrete evidence to prove that bias influenced the decision.
So there just wasn't enough information that she presented, right? And so they just saw Hart's reasoning as valid.
Yes, and they found, and this is the interesting, and this is kind of the real sweet spot. You know, the center of the cinnamon roll. When you eat a cinnamon roll, you go to a restaurant, but you really want the center, the gooey, icy, warm center, right? So this is the center of the cinnamon roll.
You don't know me very well. You know I'm not eating that cinnamon roll, right?
Yeah.
So, I know what you're saying, though. I get
sure.
It's very good.
So the sweet spot of this, the court found that Hartz, the big boss, sincerely believed that Griffin was the stronger candidate, and the decision wasn't based on discrimination. And like I said, that's the key point. The court isn't judging whether the decision was perfect or fair. The court is judging whether it was lawful. So
what's the reasoning behind that? What's the court's reasoning behind that?
Yeah, so the court said, you know what, while Gwendolyn was qualified for the position, the DFAS and the leadership there, when they selected the other candidate, they provided legitimate, non-discriminatory reason for choosing Mr. Griffin. They noted his vision, his leadership, his strategic thinking, and the court emphasized that subjective assessments, like evaluating leadership potential, are valid as long as they're not a cover. They're not a cover for discrimination. And importantly, Gwendolyn's heartfelt belief that she felt she was more qualified wasn't enough to prove what they call pretext.
Whew, that's a lot, right? And so again, I feel for her, but I see where there was a process in place that was really looking to get the right person in that role. And so, Chuck, what's the bigger picture for our HR departments of one, our HR departments, our small business owners? What is it? Tell me.
Oh, sure. Yeah. So the bigger picture here, it's more than just about one promotion. It's about hiring practices and how they affect trust and morale. You know, subjectivity can be a double-edged sword. On one hand, it allows organizations to consider soft skills that may not appear on a resume. On the other hand, it can feel arbitrary if, and here's the key phrase again, the sweet spot in the cinnamon roll, if it's not documented properly.
Yeah, right. And so if the employees, right, the candidates that are applying for these jobs do not understand, this was internal, right, does not understand the criteria being used, they may feel like the deck is stacked against them. They're like, oh, I'm trying to, but I don't know what you're looking for. So I'm going to do my best thinking, oh, I think it's going to be these things, right? And so, but if they're over here looking for something else, then that's not, the deck's going to feel really bad.
Yeah. And in my research, I ran across Eric B. Meyer. Eric writes a blog, The Employer Handbook, and you and I subscribe and we read his stuff. And he's kind of fun and whimsical, but he provided a sharp observation here. He said, the subjective evaluations like gut feelings about leadership can be legitimate as long as they're applied fairly. And Meyer notes that subjective judgments should never mask discriminatory intent, but they can be valuable in roles that require vision and collaboration.
Yeah, so the issue isn't here using subjective criteria, and I would argue a little bit about that, right? Because you have to have clear expectations and define that, okay, this is what we're looking for. We're looking for leadership qualities. By leadership qualities, we mean these behaviors, right? So get into some of that there, but it's whether they're applied consistently and then documented properly, right? And so we assume, I'm going to go on here a little bit, we assume please. That when there's leadership qualities there, if we're making the assumptions like, okay, this is what leadership quality is, and it's not being clearly documented, and then not capturing people's answers and not having that. Look, when these court cases come down, typically the employer's wrong until proven innocent, right? It's just, that's typically the way it works, right? And so, but if you don't have documentation, if you don't have clear procedures about this, that's when you're going to get in trouble. And so having like, okay, this is what we're looking for. Here's the job description. Here's the 7 competencies that we're looking for. Here's what each one of them means. Here's the questions we're asking. Here's their answers. And having that for each candidate is going to give you like, okay, here's why we did it that way. That's going to do it. Even if it tends to be subjective, you're going to be in a better place.
Yeah. So I was going to go over my 5 lessons for HR practitioners, which you pretty much hit most of them. Document everything. And that's the key here is this case on the company side. It was documented. They had detailed notes and they had evaluations. They were consistent. They used structured interview questions for all candidates. They were transparent with the employees, and you have to be transparent, explain promotion criteria and provide feedback to build trust. Balance those hard and soft skills. You have to define the role of intangibles though. And then, the perception issues, you have to combat them. Regular communications about career path and expectations overall, not just for this case, but overall can reduce those misunderstandings that foster mistrust.
Yeah. And don't forget, right, that perception of bias can damage morale. And it's interesting in this story where you had one supervisor move off and then you had a new supervisor come in, probably with a different take, right? My assumption is one supervisor probably talked to her and said, this is what I'm looking for. He leaves and then somebody else comes into this role. That person has a different vision for this. And maybe I'm not getting that communicated to me. Maybe I'm not being clear about that, right? And so I think all of that plays out. And as employees, when we're applying for jobs, we need to make sure not only to read the job description, but if it's internal, reach out to that person and say, all right, what are you really looking for? This is what I'm seeing on the resume. These are the things I want. But what else? What are the intangibles that I need? Because that's going to better prepare you for that job for sure. So HR needs to show, not just tell, that their processes are fair.
Yeah. And, the cautionary tell, and I'm going to say to our listeners, think about your hiring promotion practices. Are you documenting every step? And not just hiring practices, but a lot of times, John, people forget about the promotions, that they really need to document those and balance those intangibles and, to avoid lawsuits, but not just about avoiding lawsuits. They're about building, and I know this is your favorite thing too. It's more about avoiding lawsuits. It's building culture where employees trust their organizations.
No, I love that. Yeah, I love that. And I love that making sure, like, everything we should be doing in HR is about building that culture, right? Building trust, building all those kind of things. So good. Chuck, I love that you gave us that deep dive and went into this one a little deeper than we were seeing in the news, went through that. Let's give a shout out to Eric, right? Eric Meyer, the Employee Handbook, always good. Definitely check out his newsletter, get it. We'll see you all the next time on HR Stories, where there is a lesson in every story.
Take care, everyone.
Thank you for listening to the HR Stories podcast. The material presented in this podcast is for informational purposes only. Chuck and John always recommend using an employment lawyer or HR consultant to handle any legal concerns or HR issues. We do our best to double check sources and make sure the information we are providing is accurate. We may eliminate or embellish without changing the basic narrative to make the story easier to understand. In certain circumstances, we may change identifying information to protect the innocent. The HR Stories broadcast is brought to you by the team at HR Stories. The team at HR Stories is designed to help anyone with HR responsibilities be better at managing the employee experience. To engage with us, go to the hrstoriesteam.com and learn more about how the team at HR Stories can support your business or nonprofit. Thank you for listening to the HR Stories podcast, where there is a lesson in every story.